Thank you for joining us this morning for our webinar dealing with the problem of unlawful evictions, unlawful lockouts, and what kind of violations will identify a violation and what remedies and what actions can be taken when that occurs. First off, this webinar is being recorded. Questions should go in the Q&A, not the chat. You can enable closed caption as necessary. And this webinar is only intended to provide general information, not legal advice or information specific to a particular situation. If you need more specific information, see the contact information at the bottom, fairhousingdetroit.org, 313-579-FAIR, or info@fairhousingdetroit.org. You can contact us any way that works for you. Video is going to be put on our website under Fair Housing, under services and resources on our website. The video and PowerPoint will also be, again, the PowerPoint will also be posted. I already have an outline on there from this webinar as well. That's already on our website. Videos of other webinars and conferences were also available for you. Hats off. Thanks to Mishta. Shout out to Mishta for generous support, making this webinar possible and other webinars possible. Without the support of Mishta, this would not have occurred. So here's kind of the FAQs we're going to look at. What is a self-help eviction, and is this permitted? What actions by a landlord constitute an unlawful eviction? Can a landlord turn off utilities? Or what situations can a landlord turn off utilities? Can a tenant recover damages from a landlord? If so, what kind of damages can be recovered? And what's the time limit for a tenant to file a case? And when I use the word tenant, I'm using it in an all-inclusive way, which would include someone who's in a property as a condo owner, being evicted by a tenant, a condo board, or co-op property, in different situations like that. But when I say tenant, it can also refer, for example, to someone who has a mortgage and is being evicted by their mortgage company. So I'm going to consider them, because the anti-lockout statute applies in all of those situations as well. But before we get into, the heart of this webinar, let's look at a short video. It's not a Michigan one, but it's from Tennessee, but same situations occur. Commonplace around the country, sadly, and it kind of illustrates, what a self-help eviction, putting someone out, looks like, right? When someone does not use the court processes they're required to do. So let me show the video real quick. Thank you.
A Nashville woman had her power cut off while her kids were trying to attend virtual school, Rory.
It wasn't because she hadn't paid her bill. It was because her landlord wanted her out so he could demolish the home. Our investigative reporter Ben Hall sheds light on the disturbing way some renters are evicted even during the pandemic.
I mean, it's just disgusting that someone could do anything like this.
Gerald Wilson couldn't believe how he was forced out of the home he'd been renting for 3 years.
No warning at all. So considering that this is extremely low down.
It was days before Christmas when the owner suddenly shut off the power.
Me and my children have to find somewhere right now to go.
Isis Tucker Rowland also lived in the single family house with her 2 children.
I have 2 children that was getting on virtual life. And then the power shut off in the middle of them.
Rowland says she paid $200 rent every week for one of the 4 bedrooms. Wilson and 2 other tenants rented the other bedrooms.
With this COVID going on, it's hard for you to go to somebody else's house with 2 children.
Rowland was caught off guard that December morning, so she called the Nashville Electric Service.
It's cold. You know what I'm saying? It's already cold in this house. I got 2 children, like right now.
We obtained recordings of her calls to NES, including one where the NES representative called the owner of the property and put him on the line.
I am actually trying to put a new house in there. I need to demolish the house as soon as possible.
On the 3-way call, Rowland spoke directly with the owner, whom she'd never met, and asked if he knew there were tenants in the house who now had no place to live.
It's impossible that there should be somebody living. There is no any contract. There is nothing that, to my knowledge, is there. The contract, the house is under my name. The NES is under my name.
The owner told NES the residents were in the house without his permission and claimed he had told them to vacate the house 60 days ago. But Rowland told us she had been living in the house for 2 years and showed us a copy of a lease agreement signed in July by the same property manager they had been paying for years. A local church had even used federal CARES Act money to help both Rowland and Wilson pay their rent, which they said had been paid up through the end of the year.
So the family's here. They're within the house, we gotta try to move by Monday.
Not by Monday, as soon as possible.
It's very disturbing, and you see more and more of this. The former judge and Metro Councilman Nick Leonardo said there's been a moratorium on evictions because of COVID, and landlords should never cut off power while people live inside the home. But he said some landlords are desperate to get renters out.
There's absolutely no way that these people could have been evicted with this moratorium. And so you see desperate times call for desperate measures. And so individuals are taking really egregious actions.
And I have 2 children virtual learning.
It's tough to hear. It's extremely hard to listen to.
We played the call for Councilman Brandon Taylor, who represents the area.
These stories happen more than we want to know or more than we think.
He says 83% of the people in his North Nashville district rent. He tried to pass a bill in the Metro Council that would have required landlords give more notice to tenants if they plan to sell their property, but it failed.
There's opportunities, I think, that will arise out of this conversation where the council can act.
But that may not be true. The Tennessee State Legislature is considering a bill that would prohibit local governments from passing regulations that add to or conflict with the Uniform Landlord-Tenant Act.
My house empty, we brought to demolish it, and the NES was supposed to take out the meter.
The power was never turned back on. The house was demolished. Despite regulations designed to protect her, Roland and her kids had to find a new place to live that night.
It's happened so fast. So then I had to just make a way and go try to find other options.
That's pretty bad. Unfortunately, that occurs far too often, right? The landlord, using that self-help, got the tenants out without going through the court process. So here's our agenda for today. We're going to look at the policy underlying the anti-lockout statute. We're going to see it deals with the problem of self-help evictions, which is the video clearly showed. And we're going to look at whether the 2 parts of it, one can be force, using force in an unlawful eviction. Another part can be interference, causing an anti-lockout violation. And then we're going to look at what kind of actions by a landlord do not constitute unlawful interference. We're looking at court action for possession and damages and what kind of damages can be recoverable. And last, we'll look at other kind of claims that can be raised. And hopefully this information is helpful in arming you with the tools that you need to deal with this, whether you're going through that situation yourself, or you're working at an agency that works with tenants, or, as you're wearing a legal hat and you need case citations and that in order to handle these cases. So first off, what policy underlies the anti-lockout statute? At common law permitted landlord to do self-help evictions. The landlord is, then using own resources to do a self-help eviction, doing whatever landlord feels necessary to get a tenant out of the property. The anti-lockout statute was there to eliminate self-help evictions, to avoid a breach of the peace. It applies whether or not the tenant is rightfully in possession and incorporates the concept of construction eviction. We're going to take a little bit closer look at each of these right now. At common law, landlord could use reasonable force to remove a holdover tenant. A holdover tenant is a tenant that has already received, say, a 7-day notice or 30-day notice, and then remains in after that time period has expired. For example, it's a 7-day notice because rent hasn't been paid. The tenant has 7 days to pay the rent or move out. If the tenant stays on past the 7 days, common law landlord could just come in there and take the property possessions out and get the possession back. That was common law permitted this, right? Or someone stays in past a 30-day notice, or someone who's an unauthorized occupant of this land. But very early on, because of all the problems that occurred with these common law self-help evictions, Michigan passed an anti-lockout statute to prohibit self-help evictions. So what's the policy underlying the anti-lockout statute? Well, again, it eliminates self-help evictions in favor of the judicial process. And it's intended to avoid breach of the peace, meaning conflict on the streets, people fighting, maybe the eviction type self-help eviction escalating, someone getting hurt, that kind of a thing. And also applies whether or not the tenant is in rightful possession. Right? Tenant may be staying on, allegedly, actually has no right to remain in the unit, but regardless, the landlord has to go into court in order to get the eviction accomplished. And it also incorporates the idea of constructive eviction. Constructive eviction is where the actions by a landlord or omissions by a landlord basically deprive a tenant of the beneficial use and enjoyment of the rental properties or the property that the landlord is providing to the tenant. And as a result, either the landlord is denying someone the use and enjoyment of the premises or really forcing them out. That's a constructive eviction. So the anti-lockout statute incorporates that. If there's a constructive eviction, that will constitute a violation of Michigan's anti-lockout statute. So first part is forced or unlawful action. First subsection of the anti-lockout statute, subsection 1 says, any person who is ejected or put out of lands or tenements in a forcible and unlawful manner, or is being kept out afterwards and held and kept out by force, is entitled to recover 3 times the amount of his or her actual damages, that 3 times his trouble damages, or $200, whichever is greater, in addition to recovering possession. The earlier standard, going way back in a Michigan Supreme Court case of Shaw, it said that in order to be a forcible eviction, right, the action must be riotous or personal violence must be used or some way threatened. Must in some result in inspire terror or alarm on the persons evicted or being kept out. Not merely force used against or upon the property, but force used or threatened against persons as a means of getting them or expelling them from the unit or premises or keeping them out, right? More recent standard, this is the federal district court case. It says that the Shaw standard was the earlier standard, and here J.P. Morgan Chase argued it in that case that it required personal violence or riotous force. But Michigan courts in more recent decisions have gone to a more inclusive definition of force. What does it mean in time? It's evolved over time such that, for example, merely locking out a plaintiff is sufficient use of force to give rise to liability under the anti-lockout statute. In this case, plaintiff alleged she was locked out of her condominium unit by J.P. Morgan despite being entitled to possession of the property. And the federal district court held that this appears to state a plausible claim under the Michigan anti-lockout statute. Another federal district court, this involving Aquin Loan Servicing, similar standard. A defendant argued that their claim would fail because of no evidence physical force or violence was used in connection with the lockout. Again, or trick or carried out under false pretenses, and the tenant is prevented by force from re-entering the premises. So here, the evidence didn't show that the defendant was forcibly removed from the premises. However, once the resident, right, or tenant was out of the unit, the tenant was kept out by the police. And the officer testified, right, similar that this eviction was similar to other evictions where the tenant was restrained, whatever that would mean, from entering the premises during the conviction. And the court found that that would be sufficient. Right. So that's the standard for force. Often, though, the eviction involves an unlawful interference. An unlawful interference occurs, right? And there's several ones. You can see subsection 2, A through G. It can be a tenant in possession whose tenancy is unlawfully interfered with by the owners entitled to recover his or her actual damages or $200, whichever is greater. Notice here, if it's an interference, it doesn't have 3 times, no treble damages, just actual damages or 200, whichever is greater. And so unlawful interference occurs where there is use of force or a threat of force. That kind of overlaps with the first subsection, however. It can involve removal, retention, or destruction of personal property of the tenant, changing, altering, or adding to the locks or other security devices on the property without immediately providing keys or unlocking devices to the tenant or person in possession, boarding the premises that prevents or deters entry, removing doors, windows, or locks. And there was a situation where, for example, a landlord took the front door off and just left it open to get the tenant to move out. That's an interference. Are causing by action or omission, termination, interruption of a service, such as heat, running water, hot water, electric service, gas service. And again, it depends whether, for example, the utility service is in the tenant's name or the landlord provides it. But, there are landlords that have called up and said, DTE or whatever, turn off the heat. And that would be an unlawful interference. There's also introduction of noise, odor, or other nuisance. We had someone call up saying the landlord was making noises, having noise made, sound and horns in the parking lot, all hours of the night to get the tenant to move out, right? That's introduction of a noise, odor, or other nuisance. Going back to subparagraph F, by action or omission, right? An omission would be, for example, a landlord not paying the water bill. If the landlord's obligation is to pay the water bill, if the landlord doesn't do it, and the water gets cut off. Omission, failing to repair, provide for a hot water tank for months on end. That's unlawful interference. Those are all things that will violate the anti-lockout statute. So first thing is the occupant must be in lawful possession of the premises, subsection 5. An owner's actions or landlord's actions do not unlawfully interfere with an occupant's possession of premises if the occupant took possession by means of a forcible entry, holds possession by force, or came into the possession by trespass without title or other possessory interest. A lease would be a possessory interest, obviously, right? However, if someone stays on past the expiration of the notice to vacate the unit, either for non-payment of rent, termination of the tenancy, damage to the premises, they're still covered. They're just holdover tenants. Holdover tenants still are in lawful possession because they were in lawful possession when they moved into the unit, right? That extends if they stay on past a tax sale or mortgage foreclosure sale. And so the Michigan statutes in the Barron versus Federal Home Mortgage Loan case, the federal district court case, it doesn't draw any distinction among the various categories of tenants at will, by the years, or sufferance. It includes all of them. So that's who's covered. Tenant must be in lawful possession. Normally that will be the case where there'll be lawful possession. So what actions by a landlord do not constitute unlawful interference? The key one is this: the owner's actions, subsection 3, do not unlawfully interfere with possessory interest if the following apply. The owner acts pursuant to a court order, right? Court order, the Sewell case by the Michigan Supreme Court, person's not improperly evicted. There is no violation of the anti-lockout statute if there's conducted pursuant to a court order. The Sickles case by the Michigan Supreme Court 2007 went so far as to call for immunity against landlords, owners, for actions taken pursuant to a court order of eviction. And you can see Sickles at the bottom there as well. So plaintiffs, example 1 is a Barnaby case. Plaintiffs argue the eviction was unlawful because the housing provider removed the personal property, placed the items outside, put a no trespass sign on the property, embarrassed the plaintiffs, prevented the plaintiffs from moving their belongings, right? This is not a violation of the anti-lockout statute because they received a court order granting them full possession of the property. Same thing here in the Verode case, right? A claim was brought under the anti-lockout statute. And here the landlord says the plaintiff was evicted from the property pursuant to an order of eviction issued by the district court. It was introduced into the record. In this situation here, it kind of, the tenant is the defendant in the eviction case, but then when the tenant brings a separate claim under the anti-lockout statute, the tenant becomes the plaintiff. In this case, the tenant is the plaintiff. The landlord becomes a defendant in the claim under the anti-lockout statute. But here, case gets dismissed because the landlord had an order of eviction. So therefore, it's not going to be reconsidered in a separate claim. Well, it was wrong that the landlord got the order of eviction. If that's the case, then the tenant has to challenge that, appeal the order of eviction all the way through the court process. If not, and the tenant just turns around and files a separate case against the landlord under the anti-lockout statute, the case will be dismissed because you can't challenge in a separate case the previous order of the district court issuing a judgment of possession or order of eviction. Another defense to an anti-lockout violation is that the owner is making needed repairs or inspections. Subsection 3, owner's actions do not unlawfully interfere with possessory interest. If the owner interferes with possession only is necessary to make needed repairs or inspection and is only provided by law, right? People don't like the owner, right? Landlord coming into the unit, they have some limited right to do it, to make sure everything is fine, do required inspections or make needed repairs. They also, that's something that should be specified in the lease. Obviously, there should be reasonable notice given, but that would not constitute, landlord entering it for that purpose does not constitute a violation of the anti-lockout statute. Another one, this comes up a bit more often, good faith belief that the tenant has abandoned the property. If the owner is not charged with unlawful interference in violation of the anti-lockout statute, if they believe in good faith that the tenant does not intend to return, right? So it means a good faith belief tenant has abandoned the property. And there's also a requirement that the landlord make a diligent inquiry to believe the tenant does not intend to return. And there's an additional requirement that the current rent is not paid. If the rent has been paid, then there is no abandonment. So it has to be all of these things. Here's a couple case studies. First one is abandonment. This is a residential lease, right? The trial court found in good faith that the tenant abandoned the premises, and then the landlord made diligent inquiry to believe that the tenant was not intending to return and the current rent had not been paid. So what happened is, it shows, I'm going to go through and read it in detail. You can, stop the video and take a look at that. But here, defendant's wife had been checking, monitoring the property, taking pictures. They made attempts to contact the tenant. They found that all the items were moved out of the home. There were no belongings in the home. Also, very, very importantly, the landlord attempted to inform the tenant that the locks were going to be changed and did so. And they did so because every items were moved out. Also, it was undisputed that the current rent was not paid when the defendant changed the locks. So based on that, the Court of Appeals found that the evidence supported the trial court's decision that the exception to the anti-lockout statute applied because it was a good faith belief that the tenant had abandoned the property. Therefore, the anti-lockout claim was dismissed. Another situation, Anderson versus Great Lakes Property, right? The plaintiff admitted in trial court found, although he had not paid rent for 7 months before eviction, non-payment of rent standing alone is not sufficient for a landlord to exercise self-help under the statute. Self-help meaning the landlord taking possession without filing an eviction case in court. There must be also a good faith belief that the tenant has abandoned the property. If the tenant has abandoned, of course, the landlord can then go in and, do whatever the landlord would like to do with the property. But there has to be good faith belief to do it. And so what happened, property owner is required to make a diligent inquiry as to whether the tenant has abandoned the property. In this case, the trial court didn't explore whether the inquiries to DT and the water board about the services were sufficient to give them a good faith belief, right? As a result, right, question of fact remained as to whether the lease had been abandoned. There had been abandonment of the lease, so therefore the court appeals remanded it back to the trial court for further fact finding on these questions. There's also abandonment in a commercial lease situation. The anti-lockout statute applies to commercial leases, right? Non-use is insufficient, must be rather accompanied by some act showing a clear intent to abandon. The court in this case found that there was a clear intent. What did they find out? They found that Baby Buford was the name of the tenant, stopped paying rent, removed a trash dumpster, water was shut off, and other items of personal property removed, and the property had not been maintained. The Baby Buford Port Huron had a Checkers franchise. They were only allowed to use the property for a Checkers franchise, and they stopped doing it. The sign was taken down, and that's a breach of the lease because the property was supposed to be used as a Checkers restaurant. And so all of these factors, right, showed sufficient grounds to believe that the lease had been abandoned by Baby Buford Port Huron. That there's Checkers' name was gone, was covered up. Photographs of the building showed that it was no longer being maintained. So those are just examples. There has to be, again, good faith belief, documentation that the property has truly been abandoned, and there must be a non-payment of rent in order for a landlord to then not go through the court process and still take possession of the property. If there's a dispute as to this, of course, the safest approach would be for the landlord to just go through the eviction process in court if there's any doubt about whether the property has been abandoned. However, to take over the property where there hasn't been an abandonment gives rise to liability under the anti-lockout statute. There's a couple other exemptions. One is death of a tenant. I'm not going to go through all the various subsections because they're very, very detailed. MCL 600.29183D. They're largely self-explanatory, but there's quite a bit of steps that the landlord must go through when a landlord believes that there's been a death of the tenant, such that the landlord then wants to go in and take possession of the premises. So, key questions. What's the procedure for a court action for a possession? If the tenant's been put out, what kind of court action can a tenant take to get possession back, and what kind of damages can be recovered? Well, first off, there's time limits, right? If time limits, the time limit to regain possession is 90 days. Often people don't want to go back in if there's been an unlawful dispossession of them from the unit. But if they wish to do so, they have 90 days to do so. Action for damages, however, shall be commenced within 1 year from the time the cause of action arose. That's the section. And this one here, time limits here, this statute, subsection 6, gives jurisdiction in circuit court for injunctive relief. That's not the only place, but it provides for injunction, a claim with injunction, for an injunction to be filed in circuit court, along with the claim for an injunction to restore the tenant to the premises. You can also have, under subsection 8, can also join with it an action for monetary damages. That has to be filed. Monetary damages, again, has to be filed within 1 year. Here's a case study, Carpenter versus Cedar Springs Mobile Home. This is way late, way, way late. So what happened is Carpenter filed a police report April 21st, 2013, where he reported that Cedar Springs had placed a padlock on his mobile home. He didn't file his action for the unlawful lockout until October 21st, 2022, almost 9 years later, right? This is way beyond. So his claim for conversion under the anti-lockout statute has been filed within 1 year. He was way beyond 1 year. And he's also has a conversion claim. A common law conversion claim has a 3-year limitation. We'll see that in a second. He was way beyond the 3 years as well. As a result, the complaint was dismissed. There's also injunctive relief can also be filed in district court. You can see the section here, MCL 600.57141F. This is different. This is not the anti-lockout statute. This is the Michigan statute pertaining to summary proceedings. Typically, when you think of summary proceedings, you think of a landlord moving to evict a tenant, and they do summary proceedings as what they commence in district court, or if you're in, the Grosse Pointe, it'd be municipal court. So that gets filed in district court. Few people think of the idea of actually a tenant filing for summary proceedings. And this section, right, 600.57141F gives a tenant right to commence summary proceedings in district court when the tenant has been dispossessed from the premises by means of forcible entry, holding possession by force, and so forth. So this is really the same standard that we see under the anti-lockout statute. And so here's, quoting it again. If you look at the bottom here, there's no state court administrative office form for tenants to use in initiating summary proceedings to regain possession. That's pretty unfortunate. There's plenty of forms when it comes to a landlord filing for summary proceedings in district court or municipal court to evict a tenant, but there's no corresponding court forms available to aid a tenant in seeking possession when a tenant has been unlawfully dispossessed from property. There's also, by the way, in this summary proceedings here can be filed in district court. So there's a couple options. If I go back a slide or two, the injunctive relief can be filed by the tenant in circuit court. If I see over here, it can be filed right here in circuit court. That's subsection 6. But if I look over here for 600.5711 gives a tenant the right to file as well in district court or municipal court. So there's two options available when it comes to the monetary claims. And the subsection here deals with summary proceedings initiated by a landlord in district court to evict a tenant. If a landlord files summary proceedings against a tenant can actually bring a claim against the landlord for violation of the anti-lockout statute, and that can be asserted as a defense to summary proceedings in a case filed by a landlord in district court. And you can see subsection 6 once again gives the right of tenant to file a claim for injunctive relief in circuit court. And again, if a claim is filed in circuit court, the tenant can join any action, can join claims for damages, or file the claim for damages in a separate civil action. It does not have to be filed with the claim for injunctive relief. Basically, you can split the cause of action. Normally you can't, but if the statute permits it, then obviously you can. So what are the recoverable damages? Real important. Again, as we mentioned way at the beginning, it can be the greater of actual damages, including damages for mental injury, lost wages, hotel expenses, or $200 statutory damage, whichever is greater. There's also tremor damages if force is used in the unlawful lockout. Attorney fees are not recoverable. So here, first part, force or unlawful action, again, quoting subsection 1 again, they can, if it's forced out through forcible and unlawful manner, can recover 3 times the amount of his or her actual damages or $200, whichever is greater, in addition to recovering possession. So to kind of, first off, let's go with the $200 first. The question is this: is it $200 per day or $200 total statutory damages? Just not clear. The only case I found was Shelby versus Patterson, where it even mentioned that. In that case, the circuit court, there was a district court order, right? And the circuit court reviewed the district court decision in an anti-lockout case. And there, the circuit court awarded judgment on the counterclaim under the anti-lockout statute and awarded $20,200, which amounts to $200 per day during the period in which heat was required but not provided. The circuit court, however, in reversing the circuit court's judgment, noted that error abounds in this case and did not address the appropriateness of the $200 per day, excuse me, calculation. It's real unfortunate. So I don't know. All right, guys, I guess you could make the argument of $200 a day. I don't know if you're necessarily going to get it. My gut feeling is it's probably an uphill battle, probably wouldn't get $200 a day as statutory damages, but it's worth arguing. So actual damages in Thompson, the actual damages here was $5,000 for loss of personal property. And the court, as going to fact finding, the trial court found the plaintiff lost bedroom sets, a table and chairs, toys, and clothes. There was some conflict in the testimony. The plaintiff, Thompson, submitted a computer printout to support the valuation of the cost of the replacement items. And the court made credibility assessments. The actual recovery was far lower than the $30,000 requested by the plaintiff. So again, nothing be at the bottom is a kind of important statement. Court need not calculate damages with mathematical precision, but must do the best with the evidence presented for it. And this, the court upheld the $5,000 award for loss of personal property as elements of actual damages. There's a real key one. This is an old case, old federal district court case, Shaw v. Castor, which had fair housing claims and anti-lockout claims. And here the court found the locks were changed without providing keys to Shaw and Moore, the two occupants or tenants in possession. The question was actual damages. And the court found that the anti-lockout statute provided damages, which included damages for emotional distress, embarrassment, and humiliation that they suffered as a result of the lockout. There's another more recent case, Christie versus Vick, where it says that actual, I do not think this case is necessarily good law on the point about exemplary. It says the case law makes clear there's a distinction between award of exemplary damages and award for mental anguish as a component of actual damages. The long and short of it is this: do not claim exemplary damages. It's probably not permitted under Michigan law. However, someone can claim a damage for mental anguish as a component of actual damages. That is something that will be recoverable. So that making clear here. You can get actual damages include compensation for mental injury, but not something separate as award of exemplary damages. Here's another case. Actual damages include compensation for mental injury. And you can see Thompson versus Freeman kind of cut the other way. The court said, in addition to awarding economic damages, the court also awarded $25,000 to Thompson and $1,500 each to their minor child for emotional distress. This is improper. The general rule is that compensatory damages are not awarded for emotional distress caused by the mere loss of things. I don't think, right? That's, well, maybe if it was phrased that way. So see, if someone is seeking emotional distress by the loss of personal property items, that's questionable. I would say the safest approach is to say that you suffered emotional distress, emotional injury as a result of the unlawful eviction in violation of the anti-lockout statute. But it's something to be aware of. Okay, so that there is somewhat of a split. Courts are kind of hesitant on this, but I believe the better approach, and the ones that courts will likely follow, is that damages for the actual damages include compensation for mental injury. There is also a question as to whether recovery under the anti-lockout statute is available only to the actual tenant or whether it extends to other occupants. And there's a couple cases that have looked at this, right? In the earlier case, defendant, you can see at the top, in Thompson versus Freeman, defendant contends the court erred in awarding damages to Rothwell, Temple, Rice, and Syria, because these plaintiffs were not tenants. And the court here in Thompson v. Freeman said they agreed they weren't tenants, but they do not agree that the anti-lockout statute precludes recoveries for these plaintiffs. And the court first, referred to Nelson versus Grays. Nelson versus Gray said that the term tenant in the anti-lockout statute is intended to include individuals who pay consideration to the landlord for the right to occupy the rental property rather than members of the larger family unit dwelling in the rental property. So the Nelson case excluded minor children living with the lessee as tenants or living with the tenant in the lease and they were did then Court Nelson did not allow recovery under the anti-lockout statute, right? In this situation, right, the Rowell was not a party to the lease. He also wasn't a tenant. And he said that the court said the trial court erred in awarding these parties damages in the anti-lockout statute, right? Now, here's the question. If you look at the last part of it, on appeal, tenants argued that the non-tenants were entitled to recovery damages. The bottom paragraph is real crucial. The court found that even where occupants are not tenants, the statute requires the landlord to resort to judicial process to remove such occupants rather than summarily remove them by the exercise of self-help. The idea is this: if you looked at an eviction case, you'll see that, for example, the plaintiff will be the landlord or owner, and they have on the summons and in the complaint versus so-and-so as who's the tenant, and he lists the proper, the address of where the tenant lives. But if it's done right, it's going to say the tenant and all occupants, because they're using the judicial process to evict not only the tenant, but all occupants. If the eviction case only says, so-and-so moving to evict so-and-so tenant and does not say all occupants, then only the tenant has been evicted. The other occupants have not. So there is a requirement that the court process be used to evict all occupants, not just the tenants. So therefore, if that is a requirement for a landlord to evict people who are lawful occupants, but not tenants, I believe would be a violation of the anti-lockout statute. Again, this is something to be argued, right? Something to be argued. You can see the Michigan Court of Appeals in 2014, right? Went the other way on this question. Tenant only includes those parties on the lease that pay consideration to the landlord, like a regular tenant, for the right to occupy the property, and that does not extend to minor children or other family members who happen to be occupying the property. That's a 2014 case. And I found a 2011 case, the most recent one that I found, right? It had, for purposes, this is actually a mortgage foreclosure case, but a tenant individual or individuals who pay consideration to the landlord to the right to occupy rental property. That's what the statute says, as opposed to members of the larger family unit. That's a Nelson versus Gray decision. Mere possession of premises doesn't establish a landlord-tenant relationship and so forth, right? And this situation is a mortgage foreclosure, kind of a different kind of a situation where the plaintiff's deceased husband had an obligation to pay a mortgage, but the plaintiff herself, I guess the wife or spouse, she never had any obligation to pay tenant to National City Mortgage. So therefore, she would not have the right to bring a claim, right? So that's something really to be considered. Certainly name the tenant in an anti-lockout claim, but think long and hard. I would still add other occupants, whether it's children or other people who are living in the unit. I would add them as well and see if the court will allow them to obtain a recovery. One note should be something that should be mentioned. Once someone has been forcibly removed from property or not allowed by force to re-enter, or their possession has been interfered with, it discharges the tenant from responsibility to pay rent. Now, that is true when someone is completely put out. If there's been an interference, for example, say no hot water, the landlord doesn't fix the hot water tank, that goes on for months. If the landlord then brings a claim for non-payment of rent, you can entitled to assert that as a defense to the landlord's claim for non-payment of rent. And actually, Michigan law requires a judge or jury to offset the amount of rent, owed to the landlord by the damages or injury to the tenant during the time period that heat or water, hot water, or whatever thing, utility was not provided. Okay, so that's something to keep in mind as well. Little note here: attorney fees are not recoverable under the anti-lockout statute. That's pretty clear on that. If someone needs to recover attorney fees, they're going to have to obtain attorney's fees through other laws or other claims that can be filed. So let's look at those right now. So what other claims can be raised after an unlawful lockout? There's several of them. One is common law conversion, meaning what? The landlord not only removed the items, took the items, kept the items. That's conversion, by taking possession of someone else's property. A real important one is statutory conversion. You can see it, MCL 600.2919 subsection A, and I have it quoted down at the bottom there. But a person, well, why this is important too is I believe almost all of these other related claims here have 3-year limitations period. So if someone is beyond the 1 year for purposes of obtaining a recovery under the anti-lockout statute, the limitation period can be extended up to 3 years under these other claims. So statutory conversion, what does that consist of? Well, by the way, it provides again for trouble damages, 3 times the amount of actual damages sustained, plus costs and reasonable attorney fees. So attorney fees can be recovered for statutory conversion, but you have to show that the landlord stole or embezzled property or converted property belonging to the tenant, or the landlord's buying, receiving, possession, concealing, or aiding in the concealment of property of the tenant. You can have the statutory language here. And also this statutory conversion claim can be joined with any other claim. Other claims include trespass. Trespass is the landlord unlawfully entering into the property premises of the tenant. Trespass to shadows, meaning trespass going into the personal property of the tenant as well. There can also be a claim for breach of the covenant of habitability. Not maintaining utilities or keeping the unit in repair violates covenant of habitability, which under MCL 554.139 applies to all residential property in Michigan. There's also a violation of the Michigan Housing Act that the property has not kept up the code. There also can be a claim under the violation of the Michigan Consumer Protection Act, which also allows for a claim for damages, and that includes statutory damages, actual damages, as well as attorney fees. And the final claims are intentional infliction of emotional distress, negligent infliction of emotional distress. There's also common law breach of the right of beneficial enjoyment of the premises. I don't see that raised very often. And as mentioned, the Shaw v. Kasser case, fair housing violations. In their case, there was an unlawful lockout as well as a fair housing violation, race discrimination, and the court there awarded $20,000 recovery plus attorney fees under the Fair Housing Act. So to conclude, answering our questions, what is a self-help eviction? Self-help is when a landlord uses force to remove a tenant or other unauthorized occupant. Is this permitted? This is not permitted. A landlord can only evict using the court process, i.e., namely filing an eviction case in court and obtaining a judgment. Again, if we're going to list an exception to this, it would be, for example, if it's real clear evidence, good faith belief that tenant has abandoned the premises and the tenant is not current on the rent, or there's a good faith belief that the tenant is deceased, would be examples of one where there is kind of self-help, but the tenant's not there, right? So that's, but other than that, no, cannot threaten, do anything to force a tenant out of a unit, can only use the court process. What actions by a landlord constitute an unlawful eviction? Can a landlord turn off utilities? Besides using force, a landlord engages in unlawful eviction by removing, retaining, destroying personal property of tenant, changing locks, altering locks, adding locks without immediately providing keys or unlocking devices to the tenant, boarding up the premises, preventing or blocking entry, removing doors, windows, or locks, causing by action or omission termination of service or interruption of utility services, including heat, running water, hot water, electric, gas service, or introducing noise, odor, or other nuisance. If a tenant is not paying for utilities, the landlord must file in court. If a landlord attempts to do so without going to court, the landlord will violate the anti-lockout statute. Then last couple questions. Can a tenant recover damages from a landlord? If so, what amount can be recovered? Certainly, yes. Tenant can file in court to recover the greater of actual damages, including damages for mental injury, lost wages, hotel expenses, etc., or $200 in statutory damages. The tenant can also recover treble or 3 times actual damages if force is used in the unlawful lockout. What's the time limit? Tenant has 90 days to file for injunctive relief to recover possession. Action for damages must be commenced or filed within 1 year from the time the loss occurs. And other claims may have a longer limitations period. I just mentioned several of those. You see them listed here, right? So what are resources? Well, the first thing, yeah, I've quoted a lot from the Michigan Anti-Lockout Statute. That is certainly the first good step to look at what the what's required under the Anti-Lockout Statute or what constitutes a violation. On our website, under services and resources, I've got a legal outline for Michigan's Anti-Lockout Statute. I think that should be very, very helpful. Just a little heads up, I've done webinars previously through the, thank you, Mishta, for the grant on applicant inquiries, wrongful evictions. Again, this training was on unlawful lockouts. Future webinars include affirmative marketing, responsible parties for fair housing violations, sex discrimination, medical marijuana, hoarding, criminal records, what's permitted, not permitted with criminal records, residential appraisals, dealing with the reconsideration of value process. And this is really becoming a real action item. The last one, lease to own or fraud protection. So I hope you are able to join future trainings, and of course, go to our website for videos of prior trainings. Just real quick in a 2-second summary, we serve Wayne, Oakland, and Macomb counties. We've recently added St. Clair counties. Of course, we serve the city of Detroit. So we're now up to 4 counties that we serve. Our services, we receive fair housing complaints, intake, investigation. We do fair housing testing. All of these things are provided free of charge. We also answer other and assist with other housing related questions, habitability, security deposits, all of those things. We also provide a great deal of training and education. Please contact us at your convenience, 313-579-FAIR or fairhousingdetroit.org. I want to thank you so much for participating, and I hope to see you in future trainings. Thank you so much.